Hello, welcome to the U.S. Immigration News. If you or a loved one has ever gone through the process of filing Form I-130, petition for alien relative, you know firsthand how critical this step is in bringing families together, and how frustrating the delays can be. As of February 2025, the situation has only worsened. Every year, thousands of families across the United States find themselves ensnared in a protracted waiting period that can extend for months or even years. The average processing time for U.S. citizens sponsoring a spouse or immediate relative has climbed to 14.3 months, while green card holders petitioning for their spouses now face an even steeper wait of 35 months. Just a year ago, the average wait time was around 11 months, meaning delays have increased significantly. In this video, we'll look at the latest USCIS I-130 processing timelines and key factors causing the delays. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video and get started. According to the most recent data released by the United States Citizenship and Immigration Services, USCIS, the time required to process Form I-130, petition for alien relative, varies depending on the category of petitioner and the specific service center handling the application. USCIS assigns cases to different service centers and field offices, each of which follows its own timeline based on workload, staffing, and other operational factors. Let's look at the processing times for U.S. citizens petitioning for a spouse. When a U.S. citizen submits Form I-130 to request legal permanent residency, a green card, for their spouse, the processing time is determined by the service center where the petition is reviewed. As of the latest update, the estimated time required for processing these petitions at each of the major USCIS service centers is as follows. If the petition is being processed at the California Service Center, the expected timeframe for completion is approximately 14 months. If the case is assigned to the Nebraska Service Center, the estimated duration for processing remains at 14 months. Similarly, the Potomac Service Center requires an average of 14 months to process Form I-130 petitions submitted by U.S. citizens on behalf of their spouses. Petitions handled by the Texas Service Center also follow the same processing timeline of 14 months. The Vermont Service Center processes these petitions within an estimated period of 14 months as well. In addition to the service centers mentioned above, all USCIS field offices responsible for handling these petitions are currently reporting a processing time of 14 months. These timeframes represent general estimates based on current processing trends. However, the actual time required to complete an individual case may vary depending on factors such as the complexity of the petition, requests for additional evidence, and the overall workload of the assigned service center or field office. Applicants should regularly check the USCIS website for updates on processing times and ensure that all required documents are submitted correctly to avoid unnecessary delays. Processing times for lawful permanent resident petitioners. Lawful permanent residents, green card holders, who file Form I-130 to petition for their spouse must wait for USCIS to process the application. The length of time required for this process depends on whether the case is handled by a USCIS field office or a service center. If the petition is processed at any USCIS field office, the estimated timeframe for completion ranges from 59.5 months, approximately 5 years, to 178.5 months, approximately 14 years and 10 months. If the case is reviewed by any USCIS service center, the expected processing time varies between 32 months, approximately 2 years and 8 months, and 158.5 months, approximately 13 years and 2 months. These timeframes are general estimates based on current data and can fluctuate due to workload, staffing, and changes in immigration policy. Applicants should frequently check the USCIS website for updates on processing times. Processing times by relationship category. Processing times for Form I-130 vary based on the type of family relationship between the petitioner and the beneficiary. The estimated wait times for different relationship categories are outlined below. Immediate relatives of U.S. citizens. This category includes spouses, parents, and unmarried children under the age of 21 of U.S. citizens. Petitions in this category are generally prioritized and have a shorter processing time compared to family preference categories. The estimated processing time for immediate relatives is 14.3 months, approximately 1 year and 2 months. Family preference categories. These petitions fall under the Family Preference Visa system, which has annual limits on the number of visas issued. As a result, wait times for these petitions are significantly longer. The estimated processing times for each category are as follows. F1 category, unmarried sons and daughters of U.S. citizens who are 21 years or older, processing times range between 7 and 9 years. F2A category, spouses and minor children of lawful permanent residents. This category has an estimated processing time of 1 year. F2B category, unmarried sons and daughters of lawful permanent residents who are 21 years or older, processing times fall within a range of 6 to 8 years. F3 category, married sons and daughters of U.S. citizens. The estimated wait time for this category is 14 to 15 years. F4 category, brothers and sisters of U.S. citizens. Processing for this category requires the longest wait time, ranging from 15 to 16 years. It is crucial to understand that these processing times are subject to change based on several factors, including USCIS workload, visa availability, and individual case circumstances. In the case of family preference categories, the delays can be significantly longer due to the annual numerical limits placed on these visa types. Since the demand for family-based immigrant visas often exceeds the available supply, applicants may experience extended waiting periods before their petitions are fully processed. Petitioners and beneficiaries are encouraged to monitor USCIS updates regularly and ensure that all required documentation is submitted correctly to avoid unnecessary delays. Factors contributing to longer wait times. First, we've got a massive backlog. USCIS has been struggling with this for years, and despite efforts to reduce it, the numbers keep climbing. By the end of fiscal year 2023, USCIS had managed to decrease its overall backlog by 15%, processing nearly 11 million case filings. But here's the kicker, they're still playing catch-up. Then there's the issue of staffing and resources. USCIS has been grappling with understaffing, and recent policy changes haven't helped. The Trump administration's return to office mandates and federal hiring freeze have put additional strain on an already stretched workforce. And let's not forget about policy shifts. The reinstatement of stricter adjudication standards means more cases are receiving requests for evidence, RFEs, or notices of intent to deny, NOIDs, further slowing down the process. The impact on families. Now, you might be thinking, it's just paperwork, right? Wrong. These delays have real, human consequences. Families are being kept apart for months, sometimes years. U.S. citizens are having to put their lives on hold, unable to plan for the future with their loved ones. Take Ralph and Jindy, for example. Their I-130 was stuck in processing for over a year, with expectations of 3 to 5 more years of waiting. That's half a decade of their lives in limbo, all because of bureaucratic backlog. USCIS's response. To their credit, USCIS isn't ignoring the problem. In March 2022, they established new internal cycle time goals for 25 forms, including the I-130. These goals are meant to guide backlog reduction efforts and improve processing times. USCIS has also expanded premium processing options and implemented digitization efforts. But here's the thing, while these initiatives show promise, they're not moving the needle fast enough for the thousands of families caught in the backlog. So, what can you do if you're facing this daunting wait time? Here are a few strategies. 1. File early. If you know you'll need to submit an I-130, don't wait. The sooner you get in line, the better. 2. Be meticulous. Ensure your application is complete and error-free. Even small mistakes can lead to delays or RFEs. 3. Consider premium processing. If available for your case, it might be worth the extra cost to expedite the process. 4. Stay informed. Keep track of processing times and any policy changes that might affect your case. 5. Respond promptly. If you receive an RFE or NOID, respond as quickly and thoroughly as possible. Some applicants are turning to a more aggressive approach, litigation. Companies like Pro are offering services to help applicants file lawsuits against USCIS to force action on their cases. While this method can be effective, with some cases resolving in weeks rather than months, it's not without controversy. It's essentially using legal pressure to jump the queue, which raises questions of fairness and resource allocation. As we consider the future of immigration processing, it is evident that USCIS faces significant challenges in reducing current delays. The agency has set ambitious objectives, including a goal to decrease the processing time for immediate relative I-130 petitions to 6 months by the conclusion of the 2023 fiscal year. However, as of early 2025, this target has yet to be met, and processing times remain considerably longer than anticipated. Another critical factor influencing immigration processing is the ever-changing political landscape. Each new presidential administration brings shifts in immigration priorities, policies, and procedures, all of which can have substantial impacts on the efficiency and speed of USCIS operations. Future legislative or executive changes could either alleviate or exacerbate existing delays, making it crucial for applicants to stay informed about potential policy shifts. In reviewing the current state of I-130 processing times, it becomes clear that petitioners and beneficiaries must navigate a system that is both complex and, at times, frustrating. However, despite the ongoing challenges, there is reason for cautious optimism. USCIS acknowledges the delays and is actively working on solutions, even if progress is slower than many would hope. For those undergoing this process, staying informed and proactive is essential. Keeping up with the latest USCIS updates, seeking legal guidance when necessary, and connecting with support networks can all help in managing expectations and avoiding unnecessary delays. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.